Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about judgments on, number one, what are judgments, what you can and can't do, and then a little secret that a lot of people don't know about that I've never revealed it. I did reveal it in a short the other day, but I've never revealed it, not because I don't want people to know about it, is that I usually play my cards close to my vest when it comes to giving information out there that debt collectors can take advantage of, that they can, maybe they're dropping the ball on something and then they're like, someone saw my video, and then they tell their staff, hey, you need to watch out for this. But with this specific issue, I have over 17,000 emails and messages and comments. Now, someone was asking me about how can you have that many messages and comments? And then I was thinking to myself, that's when I look at how many videos I've posted over the years, more than 1,000, I think it's probably like 13 or 1,400. That's not really a lot of comments per video. So it could be like 20 per video, which is not a lot. That would be easy to follow up on. But when you add that and times 1,000 and 1,500 videos, that gets to be a lot of people who are contacting us on a daily basis. And it's mostly, this is what we get most of our contacts, is that people are either being sued by a debt collector who have purchased their debt, or people have missed their court date and they have a judgment against them and they're wondering what can they do. Because when it gets into that process, then they're trying to take their money from them. They're trying to garnish. So what I'm going to do real quick is I'm going to walk through a little bit about the process of a judgment, on how it happens, and then we're going to get to a solution that could potentially work in your favor if your debt collector forgot to do this specific thing. Okay, so first, what you're going to have a lawsuit, which is, unless you live under a rock, that the way that this is going to happen is that you're going to have a lawsuit, and it could be from an original creditor or a debt collector, a civil lawsuit. So let's keep that, make sure that everybody understands that civil lawsuit is usually, it's always about money. So the next thing is, if you do not respond to the summons, don't show up to court, don't put up a defense, they're going to get a default judgment. The judge is going to put a default judgment order on you. If you do show up and you do fight for your rights, it's still potential that you could lose your court case, and it just won't be a default judgment, it'll just be a judgment order. Once it works into that process, you have, and I'll give an example, for my state of Wisconsin, you have 6 months to have it reopened to go back and fight again. Now, if you didn't show up to court the first time, you can usually get it reopened if you can state that you're going to have some type of evidence to be able to fight. But in most jurisdictions, what I'm seeing is that if you did not make the court case, it did not make the court hearing, and you had a default judgment, most judges are allowing those cases to be reopened. You just have to file the paperwork the right way. But you do have to still respond. You can't just show up there and deny everything. So you still have to put together an affirmative defense, and you have to answer the allegations that are against you from the original creditor or the debt collector. Now, you got to check your state laws to see, what's the time frame that you're able to do it. Some states, even if it passes that time frame and you can show a violation that you wasn't properly served, or you were sick or something within there, you could even usually get an extended time frame. But they try to keep this settled within that time frame because they want to be able to let the original creditor or the debt collector continue doing their business with other stuff that they have to do. There has to be some sort of deadline, and that would be vice versa for you, which is you wouldn't want them to be able to come back and do things when they've passed the deadline, which is going to get into something very important that I'm going to talk about here. So that goes both ways. So now after you have the judgment order, there's going to be a collection process. In most states, they have to go back into court, and then they have to get a garnishment order, or they're going, whatever way they're going to try to collect. If it's a business, they're going to try to get assets, or they're going to try to attach bank accounts. Or if you live in a state where they can't garnish your wages, they're going to get an order to be able to go into your bank account. They'll take that document, submit it to your bank, and then they'll try to take money from your account. Now, what they will do, though, what I see collection agencies do, original creditors don't normally do this. Original creditors will just stay really with the standard process, unless they hire one of these companies that specialize in doing these collections, which they are ones out there. Debt collectors, what they'll do is they'll do a tracing on the way that you pay your bills, the way that you're living, if you have own a home, if you rent, whatever there is. They're just trying to look at your credit reports to see your lifestyle. This is what they're doing. They may even look you up on social media. And then depending on the state that you live in, they will either attach your bank account, which there's been a lot of people who have commented on the videos that I have where they woke up one morning and the money was taken out of their account. Now, just to kind of calm down a little bit, just in case you're in this situation, they're not allowed to take all of your money. They will take all of your money, but they're not allowed to take all your money. You have to go to the courthouse, and you have to file a document, and you can either have all of the money put in and then they can take out the appropriate amount, or they will have to put in another amount in there for your living expenses. They have to do that. That is written into the law. So they can't just take all of your money. Now, if it's a business, they can dip in there because that's something totally different. If you live in a state where they can garnish your wages, then what they're going to do is they're going to ask the court to do a garnishment order. I just received one from for an employee that used to work for me with one of my other companies, and they will usually, they'll have the civil judgment, and then they would say that, whatever the percentage is in your state, they'll request that is sent to them either weekly or bi-weekly or monthly, whatever the pay period is. That's what they're going to do for that collection process. Now, let's get into the big solution right here. This is something that is not normally talked about. I'm pretty sure now that I'm revealing it, a lot of videos may get made on this. One of the things that a lot of people do not really understand about judgments is that everybody always looks at the 20-year statute. Like, there's a 20-year statute of limitations for civil judgment. So anything after 20 years, they can't come after you for. Now, there are debts that can extend past that, but for anything civil like credit card, repo debt, all of that type of stuff, 20 years is the max. But now here's the little secret that a lot of people don't know about when it comes to judgments and the collectability on judgments, is that they do expire within that 20-year period of time. Now, I've done a little bit more research. I've always usually been focused on the states that clients have either came to us and they had a question about it, and also mainly my state of Wisconsin, which is in 10 years they have to renew. So that means that if they do not renew that judgment on that 10th year, and it goes to 10 years and 1 day, it is not collectible. They cannot, it's over. And so what I've seen happen from time to time, and what we tell our clients to watch out for, is that if they're into a judgment with a collector or whoever it is, original creditor, that if you're like, in my state, you got 8 years, they haven't collected, they haven't done anything, they haven't, been coming after you, and then it makes it past that process, then you don't have to you don't have to pay it. It's just like a statute of limitations. They've like passed the legal statute of limitations for it to be able to collect, even though it was a judgment. So now it needs to be removed off your credit reports because it is totally obsolete, and there's nothing that the debt collector or the original creditor can do to come after you for that debt. So now to clarify, there is a statute of limitations for debt. That is not if it's went and they've gotten a judgment. Sometimes people, they get confused where they'll say, well, the statute of limitations in my state is 5 years, but I have this judgment, so how are they able to collect it? That's because it's two different statute of limitations. Once it becomes a judgment, it is out of the regular statute of limitations. Once it goes through civil court, becomes a judgment, it's a different statute of limitations. It's going to be within the statute of limitations for your state on renewing a judgment. So now let's just go down some of the states. Alaska, judgments have to be renewed after 10 years, and they can be renewed per 10. So really, they can be renewed one time, and then it's going to go up to 20 years. Arizona has a 5-year period. So if you live in Arizona, 5 years. So if you have a judgment, maybe you're 4 years into it, and they haven't collected from you yet, you have 1 more year and 1 day, and then they cannot collect it unless they renew it. The way that you can find out if they renewed it is you could go to your court file, wherever you could do the court lookup of your case. They will have entries in there, and you will see if they renewed it. If they didn't renew it, then you're okay. And I'm pretty sure a lot of people have actually paid judgments or done settlements on judgments, and they did not check to see if it was renewed. Arkansas is 10 years. California is 10 years. Colorado, 6 years. Connecticut, 12 years. 12 years. Let's see. Delaware, 5 years. Florida, 20 years. And renewed for 10-year period. So it's basically 10 years. Georgia, 7 years. Hawaii, 10 years. Idaho, 5 years. Illinois, which I had a client, or not a client, a YouTube subscriber, actually a Facebook subscriber, asked me the question, and there's a 7 years. Indiana, 10 years. Iowa, 10 years. Kansas, 5 years. Kentucky, 15 years. Kentucky, 15 years. So it has to go 15 years, and then they can renew it, which is going to only be for 5 years. Let's see here. Louisiana, 10 years. Maine, 20 years. So they're valid for 20 years. I'm going to get more details on that one there. Some states don't actually clarify it a lot in their laws, so you're going to have to do, you may even have to call your court clerk. Maryland is 12 years, and again, Wisconsin is 10 years. And if I didn't mention your state, you can look that up. Or you can go to my website, thecreditrepairshop.com. I'm going to be continually adding more states to our list. If you type in judgments expired, go to my blog, type in judgments expired, and you'll see a list of these here, and you can see the ones that we're adding to there. I told my staff we need to add those in there. So now, so here are the solutions. So just to do a quick review, they get a civil judgment. They take you to court. They get a judgment. Maybe it's a default judgment. You had the opportunity to have it reopened. You need to check your state laws to see what is the time frame and to see the requirements. Some of the times they say you can't reopen unless you have some sort of affirmative defense that could change the judgment order. Because remember, they're low on judges and they have a lot of hearings, and they want to try to get these out of the way. If there is a violation and it is past the time frame, in some states, if you were not properly served or you could prove some sort of violation, maybe you were, had medical issues or something, you may be able to get it reopened. Most judges are allowing those to get reopened. Regardless if it's a default judgment or a judgment where you did fight and you just happen to lose, there's going to be a collection process. If it's a business, they're gonna, try to collect on those assets. They'll try to attach a bank account. If you if you don't have a business, they're gonna go through the process by looking up how you live your life, doing the tracing of your the way that you're paying your bills, your car note, all of that type of stuff. Maybe look you up on social media, and then they're gonna have a plan of action. If you live in a state that you can be garnished, they're gonna go back to court to get a garnishment order. If you live in a state that you cannot be garnished, they're gonna go and they're gonna look to attach your bank account. If they attach your bank account, they must leave money in there for you to be able to live. They cannot play stupid, because they usually do that by doing the tracing. That's how they're going to know that it's even worth going after your bank account. And so they must, it's law that they have to leave you money to live on. But they will usually take all of the money and make you go through the work to get the amount of money that they're supposed to leave you in there. The renewal period, every state is different. My state of Wisconsin, 10 years. Some of the other states are a lot less. If it goes 1 day past the renewal period, they cannot collect on that debt. You can go through the process of getting it all removed from your credit reports, getting it closed out at the courthouse. You can submit a letter that this is past the legal collection period. It needs to be closed. And, and whatever they allow you to put as the notes in there, but you have to do that. The collector is not going to do that work for you. But they cannot collect on it. You can get it removed off your credit reports, and it's different for every state. And the rules are a little bit different, or the paperwork process is different for every state. So I encourage you to look that up so you can see how that would work. So again, closing out on this video, when I see stuff like this, I see that our country is set. If you play and understand and look at all of the different avenues and rules and I guess technicalities that are available, you can see that, right here, it could look tough for you right here. It could look very tough for you. Most people would probably think they're in this situation, all they could do is bankruptcy. Maybe you could do settlement. But a lot of people, even with settlement, they, find that they're just not able to do that because they're struggling financially. There's still another door that you can walk through if the debt collection company or original creditor does not do the renewal process. So you have a lot of doors that are available to you even before this. You have the statute of limitations. So, which is, to be clear, statute of limitations, to be clear, this is before a debt has went and got a judgment. That is a different statute of limitations. So the statute of limitations is, and it's different for every state, is that if you have a debt that is not a judgment, then it's under your state's statute of limitations for collecting debt. If it passed that date after the charge-off period, the clock starts ticking after the charge-off period, or after the debt goes bad if you're dealing with a private company. That's when the clock starts to tick for the statute of limitations. This here is totally something different for the renewal process statute of limitations for a judgment. That is totally different. So don't get those confused. Make sure, because you can end up, playing in the wrong field and end up getting yourself in trouble. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process and my 2-phase settlement process. That's the way that we repair credit. We don't do it any other way, and you can't come to us and tell us how to do our job. So if that's your plan, please go somewhere else. That's just the way that we do it. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you early in the game, before it even gets to any of this stuff, grab my 3-pack of letters. Statute of limitations letter, which you do not have to do any type of debt validation if your debt is past the legal statute of limitations for a debt collector or original creditor to be able to collect. After that charge-off process or after the debt goes bad. The clock starts ticking. If it passes that date, you do not have to pay. If it is not past legal statute of limitations, I have two other letters for you: a debt validation letter and a cease and desist collection activities letter. The cease and desist collection activities letter is going to ask the debt collector questions about the debt to make sure that they have everything in order to be able to collect the debt. Now, if you're dealing with an original creditor, what it'll do is it'll get them to send you documentation and put you into a better position to do a settlement with them. But if you're dealing with a third-party debt collector, this letter is very, very effective on stopping them. Now, I do ask for a donation with those, but it is not required. It can save you time, money, and a lot of frustration by just being able to stop a debt collector early in the game. Please subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and